Mr. Davis's matter. All right, that is page 15. Thank you. 15 is C-342-946, State of Nevada versus Raymond Tyrone Davis. He's present in custody. Mr. Mueller on his behalf, Ms. Collins on behalf of the state, has had the opportunity to review Mr. Mueller's motion, Ms. Collins' opposition. I'm happy to hear anything else. Mr. Mueller?
Thank you, Your Honor. Following up, based on the discussion and where I left off with things and where we're at now, I also met with Ms. Collins this morning to make sure I hadn't missed anything. Your Honor, I'm going to go ahead and ask the court to reinstate his bail. From my understanding that he had $25,000 bail. He voluntarily remanded himself into custody for a mental health evaluation. I asked that you go ahead and reinstate the bail. It was sufficient to make sure he came back to court, and it's been sufficient to make sure he stayed out of subsequent trouble. We're not going to ask for normal cognizance, just go, if we could get him back out of bail. He does have a business. It's not been shut for the last month or so, but if he can get back to it, he can continue to operate. He does have the same apartment he's now had for going on 10 years, 7, 8 years. I don't remember the exact number, but he's been there forever. So he was can be found easily, doesn't have any place else to go. So I'm going to ask for a $25,000 bail be reinstated and set a trial date in order to question.
Ms. Collins?
Your Honor, I think I laid it out pretty well in my motion, but just for the record, I think things have changed drastically in this case since bail was set at $25,000. First and foremost, his criminal record, if you review page 6 of my motion, and I can lay it all out on the record if you like, that was not within the knowledge of whoever looked at the risk assessment. That was not broken down. Anything that was prior to 10 years ago was not laid out in that risk assessment. He has at least 3 prior felony convictions that I can find. He was arrested in Milwaukee in '86 for robbery, no disposition. Arrested in Pierce County, Washington for assault, obstruction of a public servant. He pled guilty to obstruction. 91, possession of stolen property ×3 plus forgery, found guilty of forgery, placed on probation. Arrested in Pierce County, possession with intent, guilty of the same, that was in 91, 92, guilty of attempt to elude a police officer. He was found guilty of that, was on probation. And I guess it's important to know that this time, that every time he was on probation in Washington State, he violated that probation. So he was brought back. In fact, one of his bench warrants that was outstanding was not quashed in 2017. I only suppose it was administratively quashed because they didn't extradite him. His criminal history continues. 94, assault in Washington County, Pierce County, Washington. Unknown disposition. He was arrested in Haywood, California in 2000 for acts with a child age specific, pursuant to California PC 288. That's similar to our lewdness statute. Ultimately pled guilty to delinquency with a minor and was placed on probation. Arrested in 2003 for trespass in California, 2004. The Las Vegas case that the court is well aware of, that was kidnapping and contributing to the delinquency of a minor. He was arrested in 2005 for threatening a crime with the intent to terrorize and kidnapping. There's no clear disposition of that case. He was also arrested in 2006 in California for violating TPI. So all of that criminal history was not known back when his bail was set at $25,000. I think what is also drastically changed in this case since the inception is this defendant's behavior and his willingness to manipulate the system, to manipulate this court, to manipulate the trial. His behavior during trial in 25 years, I've never seen it. I have never seen someone be so abusive to the process, to the court, to the prosecutor, to the court staff, to everyone in here, to go absolutely right up to the line and push this court for a mistrial till he got his way. And if you read in my motion, that was completely deliberate and calculated because he gets on the phone as soon as he leaves court that day and he calls his friend Terry and he tells her, well, I knew I was going in today, so I took the dog wherever. I mean, that's how manipulative and quite honestly a little bit frightening to the state. If he is going to behave that way in a court of law, how is he going to behave now when he's out? I mean, his behavior has so drastically escalated through the course of this case. I mean, I have been called a racist. I have been called that I'm prosecuting him for some vindictive purpose, that I have mental health issues, that I am targeting him because he's African American. I mean, his version of the truth is just ludicrous at this point. It's just absolutely ludicrous, and the state thinks it makes him dangerous to the victims in this case, to the community. I mean, I can play a jail call for you from just yesterday, and the things that he believes are true, I don't think he's incompetent. I just think he is willing to go to whatever lengths necessary and say whatever he thinks is necessary to get out from under this case. I can play the call for you if you like.
So there's a few things, and I'm going to make my ruling today, but I.
Might be heard in rejoinder for this.
Oh, yeah, of course.
Certainly,
Of
Judge.
course.
Courts, and those of us who've done this for a long time, tend to be a little more emotionally detached. But every one of these cases has real emotions and energy tied up with them. That's the nature of the work. You can't survive in this work very long if you're not able to detach clinically and psychologically. You know that, Judge, you've done this. Now, what my colleague missed in her presentation, which would be a great sentencing argument, is that nothing's changed. He's been on trouble for about 15 years. I mean, it's not like it's been, you know, he's a businessman. You know, common law recognizes you go 10 years, you can't even ask about a felony. Now, he's got 15 years of generally, you know, trouble-free existence. He's in the same apartment, he's stable. The purpose of bail is not to punish. She may be unhappy with him, but the reality is the purpose of bail is to ensure his presence in court. I never heard her once in her argument mention failure to appear. Now, the purpose of the bail is to have him come back. 25 bail was sufficient to get him to come back. It's his money. I come back for $25,000. He came back for $25,000. It's fine. So respectfully, Judge, I believe my colleague might be missing the mark here a little bit. Not that everything she doesn't believe everything she's saying. That's not this issue. The issue is whether he's got enough bail to come back. He apparently, and I wasn't here, so I'm always in a weak spot when I wasn't there, but apparently both you guys were. He asked to be remanded into custody, did a competency evaluation. Now, that bespeaks, despite my colleague's skepticism, it bespeaks situational wherewith. It bespeaks the fact that maybe he's not competent, he wants to get checked out. Maybe he's not ready to deal with all the stress that gets involved in this. God forbid, I hope I'm never accused of a serious crime like this. I'm not sure how I'd handle it. Having said that, we're ready to defend him. Mr. Davis didn't have this problem with the legal system when Mr. Mader and I were able to run interference with him. I don't want to promise anything, but I think things will go a lot smoother from this point forward. And I believe my colleague might be a little more involved and look past the issue. Was the amount of bail posted sufficient to bring it back? It was.
I appreciate Mr. Mueller's commentary on what I've missed. He has 15 failures to appear in his history, and those cases remain in bench warrant. So I did speak to that.
All right, so here's the thing. Forgive me because I can't remember the case name. I want to say it's Washington, but I'm not 100% sure. That came out this year in regards to, you know, making a change in bail. Cameron, okay, thank you. Making a change in bail, the court has to be presented with things that were different when the initial bail was set. So a couple different things that I don't think the Justice Court was aware of when this happened is the defendant's use of 6 different names, 5 different date of births, and 6 different social security numbers. I don't think that there was any idea that the criminal history dated back to 1986, especially the violence offenses. But what's unfortunate, I think, for you, Mr. Mueller, is that the basis of the court's concerns were while you were not here, which is why I've tried sufficiently to lay a foundation for you, Mr. Maynard, to understand what happened during these 2 weeks. Because in all of the cases where I prosecuted crimes of homicide, crimes of sexual assault, never have I ever seen the display that I saw in this courtroom. The amount of patience I tried to exert because Mr. Davis was representing himself, the amount of times he continuously refused, absolutely refused to follow any request, any court order. told the jury multiple times that he was forced to trial without an attorney. Over and over and over again, I told him not to say it again. He got up and said it right back again, even though he chose to fire you, Mr. Maynard, and represent himself. He told me that he wouldn't be able to come back to court because his doctor had such grave concerns about the health of his foot, so I asked for a doctor's note. The doctor's note that he gave me said that he had light bruising and should take a Tylenol. He then told me that he wasn't coming back to court because he had a surgery on his foot on Monday. I kept thinking, why? He asked me every day, take this off, take this off, take this off. Why would he want that bracelet off so badly, but to leave? I even said, I will have someone take you, or would you please go down to house arrest? I'll have it moved to the other foot so you won't be in so much pain. No, I'm not going to do that. I'm not going to do that. It's either you play by his rules or you don't play, and that's not how the court system works. When his efforts weren't working, and I asked him, and I told him that I would not remand him for the house arrest bracelet issue, that I would not be taking that off. I apologize. It escalated to the point that he told me his mind was telling him to do very dangerous things, and he attempted to check himself into a mental hospital. Again, I asked for documentation. That documentation said that he needed to just go to therapy and that he was fine. When that didn't work, he tried dealing the case. This was what was most frustrating to me. He offered the district attorney $50,000. When she didn't accept that, he offered her $50,000, and he'd tell her about a sex trafficking ring he has personal information about. That was there. If you know information about a sex trafficking ring where juveniles are involved, then guess what? Go to the cops. It's not part of the deal. It's about what it's doing right. His outburst where he screamed the F word at Miss Collins over and over and over again, to where my marshal had to get in the middle because he was afraid for her safety. But another thing that brings me a lot of concern is his break with what's really happening. The fact that he says he was forced to self-represent. He was forced into competency court because he wouldn't take a deal. That he's no longer allowed to cross-examine witnesses. His realm of reality is what he wants it to be. This doesn't have anything to do with him being black and someone else being white. He does not want to follow rules. And the fact that he told me that he was having issues with competency, and then later that afternoon called this Terry lady and told her, I knew this was going to happen, that's why I put the dog somewhere, it's all part of his master plan. That brings me absolute no comfort or solace in him being released from custody. I don't know if he will come back, because I don't understand why someone asked me to take off that bracelet so many times, and I gave him the opportunity to take it off and put it on a different foot, and he denied that right. His behavior has escalated so out of control that he has lost the ability to represent himself, and he has lost the assurances I had that he would come back to court. Most concerning of all is not only the community's safety, this prosecutor's safety, as well as the safety of the victims because of the way I saw him treat them on the stand. So the defendant's motion is denied. The state's request that the bail be set at $500,000 with house arrest and high-level monitoring is granted. I will also be issuing a written decision in regards to the factors of why this decision was made in the way it was, because I'm not comfortable with the representations that Mr. Davis makes in motions in regards to the court's rulings and why those were made.
I understand, Judge, and thank you. I appreciate the thorough analysis. Two things come to mind, and I will leave this, and then I'll leave the argument that you said for trial. The last two jury trials I've done was with a defendant who was very unpopular down in family court and did in fact have some, if not sufficient mental health issues disqualifying from proceedings, certainly made it hard for him to behave. I've been able to get that man into court, kept him calm, kept him through the process. I believe that with some assurance, some confidence, that I think we can keep Mr. Davis under control. We had no problem with him in justice court. We were fine. Even in my office, we didn't have any trouble with him.
Didn't he call the liar a fucking bitch?
What?
Didn't he call the victim a lying fucking bitch in the middle of the prelim?
Yes,
That's what the transcript says.
page 16, yeah.
Yeah,
I
he
mean,
did. That's true. I touche. I didn't recall it. He did have an
one
outburst.
issue.
He did. No, he did have an outburst, and I promptly calmed him down. And he did not have another outburst again. The other thing is, Judge, respectfully, would it be better if you transferred this to another department?
Absolutely not.
Well, all right, Judge. someone else looked at the case.
The defendant sought to recuse me twice, both of those were denied. If you think that I should be recused, then I understand that, and I invite you to file the proper motion work so Judge Bell can hear it.
Thank you, Judge, I
know, I'm not taking
it's a very
offense.
frustrating line of work, and I'm not taking this personally, it just, from a detached point of view, it just thought occurred to me as I was listening.
I understand, and I don't take any offense, and if you think that's in the best interest of your client, then I am happy to pass that over to Judge Bell for determination.
All right, thank you, Judge.
Thank you.
Yeah, can we get a trial date in, I guess?
We have one.
Mr. Mueller, if you would like to speak, then I would suggest you speak to Mr. Mueller, and then
I want to speak to the court.
No, Ray, done, no. No, you've said enough. More than enough. Okay? Calendar call, Madam Clerk.
It's a February 3rd and February 10th jury trial. And it's a firm set, like we had talked about last time, Mr. Miller.
All right, thank you, Judge.
Thank you.